Hello students. So in this video, we are going to discuss about something which appears in at least one of the passage in the CLAT legal reasoning portion, that is criminal laws. Now when we talk about criminal laws, a lot of students think that all the offences which are described under IPC, they are crimes. They never look beyond that, right? Murder is a crime, we all know that. Kidnapping, abduction is a crime, we all know that. Domestic violence, right? All these are crimes. Theft is a crime. Trespass is a crime. These are some of the things that we know as crime. But crime is not specifically, or it's not confined to Indian Penal Code, right? It is more than that. All these acts, for example, POSH, Prevention of Sexual Harassment at Workplace, then SC/ST's Atrocities Act, right? POSCO, right, which talks about child abuse. All these laws, Domestic Violence Act, all these laws are also criminal laws. So when we talk about criminal laws, it's not one statute or one act defining the entire criminal offences. There are multiple laws which define criminal offences. Let's understand. See, whenever there is a passage on criminal law, it is positioned at a specific place. For example, they're talking about investigation. They're talking about bail. They're talking about arrest. They're talking about investigation. Let's talk about within investigation, search and seizure. So there can be many aspects of investigation itself. So every passage is positioned at a particular stage of this criminal process, right? So let's try to understand what is this process, who are the people, and how does the court proceed, right? What are crime? Crime, see, you must have been taught when you were reading torts that there is this maxim called ubi jus ibi remedium. That means whenever there is a right and it's violated, there would be a remedy. But there is no such thing in criminal offences. In criminal offences, it's straight away given in the constitution as well. If you read article 22 or 3, right, which talks about ex post facto laws, there also we see it. Until and unless it is defined somewhere that this is an offence, that cannot be a criminal offence. That means the parliament, the legislatures, the parliament or the state legislative assembly has to call something specifically through an act or an ordinance that this is going to be a wrongful conduct which is going to be treated as criminal offence. Only then it can be called a criminal offence. If you have read 23 ex post facto law, that also talks about this, that you cannot be punished for something, right? You cannot be punished under a law which wasn't there in force at the time when it was committed. That means if today I have committed an offense and tomorrow some law comes in which punishes my today's act, the law comes tomorrow, punishes my today's act, that have a retrospective effect. A law bringing into ambit acts which happened previously from past. Those things are not allowed. So what are criminal law? Which are specifically defined as crime by the legislature or by the judiciary. That means the law defines something as crime. Law can be a state legislature has passed a law, that is act, or it can be Supreme Court judgment, it can be custom and practices. Those things we have done in class. So anyhow, so what are crime which are specifically mentioned as offences which are specifically mentioned as crime comes under the purview of criminal laws. Then let's understand the nature. Okay, what is this nature of the offence? So whenever we talk about criminal offence, there are certain things which describe the nature of the offence. Now, all these acts, for example, POSCO, for example, POSH, Prevention of Sexual Harassment at Workplace, all this act doesn't specify the nature of the offence. This is specified, the definition of the nature of the offence is specified under IPC only. It says what are cognizable offences, right? Offences where a police officer can arrest and investigate without warrant of the magistrate, right? It defines bailable and non-bailable offence, right? Offences where you can claim bail as a matter of right. Non-bailable offences where bail is discretion of the court. So all these things, then it's warrant triable or it's summons triable, all these nature of the offence has been described under IPC, whereas classification is done by the respective act. That means under POSH, if you have done an offence, it will be given that this is a cognizable offence. But what is cognizable offence? What is bailable offence? All those things are given under IPC. IPC also talks about general exceptions and defenses, which is applicable to all criminal laws. So there is a particular portion in IPC which governs all the criminal law. And there is a substantive portion of IPC which specifically talks about offences within itself. For example, we talk about 300, 302, right? 304, all these offences related to human body. All those things are offences in itself described under IPC. Nevertheless, there can be always criminal offences which the state can describe through its legislations, right? Okay, let's understand the procedure, right? So every criminal trial starts with either complaint made to the police officer or the magistrate, judicial magistrate of the concerned area, judicial magistrate first class, or an FIR, first information report, which is lodged with the police, right? The station house officer, whenever under 154, the provision is not important, the concept is important. Whenever a person approaches the police station saying that he has the knowledge of some cognizable offense, then the police shall register an FIR. FIR is nothing but a written statement as to what that person is narrating, and the signature of that person is taken after the contents are read out to him. After he knows what has been recorded, he signs it. That becomes the first information report. Once the FIR has been lodged, if it's a cognizable offense, as I've told you, every cognizable offense, police can directly go with the investigation. Once the complaint FIR registered, directly investigation. But sometimes for non-cognizable offense, before investigation, judicial magistrate's permission has to be taken, right? Then, once the investigation is concluded, the police, through the evidence that it has procured through investigation, will go before the judicial magistrate and submit the charge sheet. Charge sheet is a summary of the offenses which the police would like to, prove in the court, or the prosecution, the state would like to prove in the court. That means in charge sheet, the charges will be mentioned. The police is indirectly saying in charge sheet that we have conducted investigation, and in investigation, it has come out that through evidences that this person might have committed, accused, remember, it's not proven. We would want to prove that this person would have done this particular offense. We have evidences, we are going to prove it. So all those offenses that are going to be tried, that are going to be proved by the prosecution, that is called charge sheet. Once the charge sheet comes in, the process of trial start. Trial is a process where the judicial body, the judge, sits and he appreciates the evidence. So both prosecution and defense give their respective evidence, and their evidences are weighed, and when the case is proved by the prosecution beyond reasonable doubt, without there being any other possibility, then the trial court gives its verdict. Verdict are two. Either it holds the person, the accused, who has done the offense, right, or who was brought to the court with regard to those charges. He can be held guilty or not guilty. When he is held guilty, we say that he is convicted. When he is not held guilty, that means he is allowed to go free. Then we say that either he gets convicted, or the second is he gets acquitted, right? So acquitted means the charges are not made out, he is not guilty, and convicted means he is guilty, right? These are some of the stages. So based on the stages, you have to understand who are the players who are in this particular thing. At investigation, the judge has not entered the scene. Similarly, at trial, the police have no role. Now the role is of the prosecution, judge, and the defendant. So you have to understand where this particular passage is set up. This passage is talking about which situation. Is it talking about complaint? Is it talking about investigation, charge sheet, trial, verdict? What? That is important, right? Now, with that particular thing, we come to the end. I hope that this was useful to you. I wish you all the best. Thank you.